Did you know the Indian Supreme Court is widely regarded as one of the most powerful courts in the world? Its expansive jurisdiction is what enables it to hold this title. This is what we'll be discussing in today's video.
To get a better sense of it, let us first understand what jurisdiction actually means. According to the Black's Law Dictionary, the word is a term of large and comprehensive import and embraces every kind of judicial action. Simply put, it is the court's power to interpret and apply the law to the facts of the case to give judgments and orders. The Supreme Court has many kinds of jurisdictions, including the original jurisdiction, the appellate jurisdiction, the writ jurisdiction, and many more. Let's get into them one by one.
First and foremost comes the original jurisdiction. Now, as the name suggests, original jurisdiction is what enables a court to hear or adjudicate a case for the first time. Now, this comes under Article 131 of our Indian Constitution, which is further subdivided into three groups. A case between the Government of India and one or more states on the other side. B, the Government of India and one or more states on one side and one or more states on the other side. Or C, between two or more states. Expanding on original jurisdiction comes Article 32, which is the article which has provisions to safeguard our fundamental rights. We, as citizens of India, have the provision to safeguard our fundamental rights when we feel like they're getting violated. And this comes under writ jurisdiction.
What exactly is a writ jurisdiction, Mishthi?
A writ is essentially a form of action that we as individuals have, which we can take to the Supreme Court when we feel like there is an infringement of our fundamental rights.
You know, Mishti, it's interesting to note that the English common law actually has more than 400 types of writs. However, when India gained independence, our courts adopted only 5 of these. Let me just give you a brief idea of what these writs are. So first you have habeas corpus, which is the unlawful detention of an individual. Then comes mandamus, which commands the government to perform an activity which they're supposed to do. Then you have prohibition, which bars the trial courts from taking an action which is beyond their purview or beyond their powers. Then you have quo warranto, which essentially questions the authority of an individual to hold public office. And finally, you have certiorari, which enables a judicial review of a lower court by its higher court.
Actually, Michelle, it is pertinent to note that even letters, postcards, emails, and news articles can be taken up by the Supreme Court as a petition in the Supreme Court of India. This jurisdiction, the Supreme Court, is also known as the epistolary jurisdiction. Even though the epistolary jurisdiction is not mentioned in the Constitution of India, it is in practicality often taken up as the PIL, or the public interest litigation. This public interest litigation of the Supreme Court of India is unique to it all around the world.
Now that is original jurisdiction. But what happens when we're not satisfied with the verdict that is given by the trial or the high courts? Now this is where an appeal comes into play.
So, Mishti, what exactly does an appeal mean?
So an appeal is essentially a recourse that one takes when one wishes the higher court to rehear the case and to probably even reconsider the points of law. Sometimes they even reconsider the points of facts. This again is subdivided into 3 categories. We firstly have Article 132, which deals with both criminal and civil matters, especially when it comes to interpretation of the Indian Constitution or points of law. Then we have Article 133 and 134, which deals with civil matters and criminal matters respectively. However, this is strictly on points of law, not on points of facts.
So you must be wondering, what exactly happens when you feel that there is a mistake in the interpretation of facts? Well, our Supreme Court has provisions for this as well. Here comes the role of Article 136, also known as special leave to appeal or extraordinary jurisdiction. Let me give you an interesting fact. Nick Robinson's and quantitative analysis of the Indian Supreme Court's workload shows us that 84.6% of the entire caseload of our Supreme Court comes solely from Article 136. Even river disputes, which are actually outside the jurisdiction of the Supreme Court through Article 262, through the Interstate River Water Disputes Act 1956, even these disputes can be brought to the purview or the jurisdiction of the Supreme Court by filing of special leave petitions under Article 136.
Really? Where does that come from?
So this was held in the case State of Karnataka versus State of Tamil Nadu 2017.
Next in the Indian Constitution is Article 137. This gives the Supreme Court the power of its review jurisdiction. This means that whenever there has been an error apparent on the face of the record, that is, there has been a grave miscarriage of justice, the Supreme Court has the power to exercise this jurisdiction. This happens when substantial evidence that needed to be taken on record has been missed. Then the Supreme Court reopens these cases and they are to be tried by the same judges. Of course, if they have not demitted the office. This jurisdiction deals with the matter of facts and not law.
Now we come to Article 143, under which comes the advisory jurisdiction. Of course, the Supreme Court of India is the apex of judicial body in India, right? So the President of India can refer to the Supreme Court when it wants to ask questions on the basis of law. These are heard by a minimum of a 5-judge bench, which is called as a
Constitutional bench?
Exactly. The Supreme Court, of course, has all power to decline on this matter, and the decisions or the verdicts or the opinions that they give is by no means binding on the President of India.
Apart from this, Mishti, the Supreme Court also enjoys its inherent jurisdiction. The Article 129 of our Constitution says that the Supreme Court can punish for its own contempt. That is, the Supreme Court can take up the case suo moto, that is, on its own conscience, or on the recommendations of the law officer, the Attorney General of India, or the Solicitor General of India. Apart from this, Article 71 of the Indian Constitution says that any issues relating to the election of the President or the Vice President can directly be taken up by the Supreme Court of India.
So, Mishti, Raghav, I think these expansive jurisdictions indeed make clear that the claim that the Indian Supreme Court is one of the most powerful courts in the world, I think this claim is validly justified.
Agreed.
100%.